Welcome everyone to our webinar, Freedom of the Press and the Public's Right to Know under the Montana Constitution. This event is co-sponsored by the Montana League of Women Voters of the Helena area and Lewis and Clark Library, and is part of a series of the League of Women Voters programs on the Montana Constitution. During this presentation, you can type your questions into the chat at any time, and our panelists will answer them at the end. Now I have the pleasure to introduce our moderator, retired Montana Supreme Court Justice Jim Nelson, who served as a justice on the Montana Supreme Court from May 1993 until January 2013. He holds degrees in business and law. Jim, the floor is yours.
Thank you, Suzanne. And thank all of you for joining us tonight on this very important webinar. We're going to be discussing some constitutional rights of free speech and press, and the right of participation, the right to know, and how that intersects with the right of privacy. And these rights are absolutely fundamental to our democracy. Without a free press, without the right to know, without the right of free speech and participation, democracy simply cannot survive. And we've got a blue ribbon panel to discuss these rights this evening. Martha Sheehy, who during her 35-year career in practicing law has represented media interests and private citizens in enforcing Montana's constitutional right to know in dozens of cases. And we have Daryl Ehrlich, who is the editor-in-chief of the online newspaper, the Daily Montanan, probably one of the best in the state. He's formerly the editor of the Billings Gazette, which took top newspaper award 6 times in 7 years during his tenure. So with that, I'm going to turn the floor over to Martha Sheehy to discuss right to know and Freedom of Information Act requests and right to know in Montana law. Martha.
Thanks, Justice Nelson. Before we go any further, I want to say thank you for including me in this panel and for your kind words. Daryl Ehrlich is one of my favorite people to practice law for, and Justice Nelson was always one of my favorite people to practice law before. So I really appreciate being a part of this panel with 2 of these men. I'm going to take you very quickly through the constitutional provisions that will be at the basis of our discussion today. There are 4 provisions that we'll be focusing on. The first is on your screen, Article 2, Section 7 of the Montana Constitution. You can read it there. It's the freedom of speech, freedom of expression, and freedom of the press provision. That's our Montana constitutional provision. It differs a little bit from the federal provision. The next is Section 8 of Article 2. This is the right of participation. And I think that this is the most underrated right that citizens in Montana have. The public has the right to expect governmental agencies to afford such reasonable opportunity for citizen participation in the operation of the agencies prior to the final decision as may be provided by law. That's the right to participation. The next is Article 2, Section 9. This is the right to know provision. No person shall be deprived of the right to examine documents or to observe the deliberations of all public bodies or agencies of state government and its subdivisions, except in cases in which the demand of individual privacy clearly exceeds the merits of public disclosure. And then finally, we have Article 2, Section 10. This is the right to privacy, which was already mentioned in the preceding section. The right of individual privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. We'll be discussing how these 3, mostly the 3 constitutional provisions, 8, 9, and 10, flow into 2 statutes, one of which is the open meeting law and the other is the right to examine documents statute. But when you're looking at these statutes together, I always think of these 3 articles, Article 2, Section 8, 9, and 10, as a 3-legged stool. You have the right to participate. It's counterbalanced by the right to know and counterbalanced by the individual right to privacy. That stool can only balance if all 3 legs are strong. And the way that our Constitution is set up those three rights are cross-referenced right within our constitutional document to establish that that balancing must take place. And before we get into all the different ways that this goes wrong, I want to emphasize that this balancing test is conducted by every public body at every meeting and every time that they're confronted with a request for documents. And 99% of the time, it works. It works really well. There's very little litigation arising out of these three provisions when compared to the number of times that governmental entities do the analysis of, does the individual's right to privacy exceed the public's right to know? So I think it's important to set the stage by saying this almost always works, because most of the time public entities are operating under these rules and everybody's trying to get it right. Press is trying to get it right. The public officials are trying to get it right. And so 9 times out of 10, it works. With that, we're going to talk a little bit about statutes. Jim, would you like to introduce that?
Well, we've got a couple of statutes. We've got the open meeting law, which is, I think we have a slide on that, or at least we have a link to it that we'll show later. The open meeting law, which is the Montana equivalent of, well, it's simply a statute scheme that guarantees transparency in government deliberations and meetings where public officials are involved. It, as Martha points out, it usually works. There are times when it doesn't work and is abused, and I think we can probably get into some of those examples later on. And so the open meetings law is 2-3-203 in the Montana Code. There's a QR code on the slide that's presented, which if you're interested in getting into it in more depth. The second law we're going to talk about is the Public Information Freedom of Information Act requests. And these are covered in section 2-6-1006 of the Montana Code. Again, the slide shows a QR code where you can find more information about those. But these are two very important laws that I know both Martha and Daryl are familiar with. And so I'm going to leave it at that and let Martha talk.
We're going to actually start with the document statute. This is 261006, and we're not going to show you the wording of that, but you can certainly look it up. The important thing to know is that there's a difference between state and federal law regarding the right to inspect documents. The federal law is called the Freedom of Information Act, FOIA. And FOIA, like a lot of four-letter words that begin with F, is sometimes used as an adjective, sometimes used as a verb, and often used as a curse. FOIA is considered a curse by many public entities. Montana statute is much simpler, and it simply states that anybody can ask for any document. In 2015, the statute was amended to allow public agencies to charge fees for the documents that are not greater than the actual cost of producing them. And Daryl and I will both talk about how that provision has put a little hitch in our giddy up. The time frame for requests is open-ended under Montana's statute. And there are a lot of problems that we see frequently, which I'll throw it over to Daryl to ask Daryl, what are the things you most see as blocked to public right to inspect documents?
Well, thank you, Martha. First, I want to say how much I appreciate Justice Nelson. And I want to say that I've practiced, this is my hometown, home state, but I've practiced in 7 different states, and we are truly lucky in Montana. And I have been so lucky to have Martha as counsel, the best media lawyer that I've ever worked with in my 27-year career. Not only a tremendous lawyer, but a tremendous human being as well. So thank you. And she is the best at, one of the great things that, because I'm a journalist, I want to go and get everything. she was always great about saying, hey, maybe you should rethink this, or that's not the best tact. And that's the best thing an editor or a journalist can have, is a counsel who sometimes says you shouldn't do that. So we've talked about it. Some people will say you should just FOIA documents, and as Martha said, it is a 4-letter F word, but that just means that people want information, and sometimes they get very frustrated because, as Martha pointed out, there's federal laws which govern federal agencies, and then state laws which tend to govern state and local agencies. So sometimes people will try to request something under a federal statute and be frustrated that it's not, the local agency doesn't seem to want to respond. So there are problems, and Martha's right. Largely when we ask questions, especially when it's documents, we get them. There are some problems. One of them is, one of the first problems we encounter is timeliness. Now, Martha was always good at telling me, wow, if we're really good at this case and it moves quickly, we'll have the result within a year. That's by the time you get judges and get it briefed and all of that. And that's pretty quick. And if you've ever covered court, sometimes a year is very quick. But for me, I have 365 news cycles in between those dates. And so news becomes relative, and its relevance decreases usually with time. So one of the things that Montana law says that can be frustrating is, unlike other states which give certain time parameters for public documents requests, Montana says reasonable. And that's one of those things that sounds very reasonable until you start getting in to the negotiation about what is reasonable. So for example, if I want one email or one document, it's probably reasonable to expect that that would be turned over pretty quickly. If I'm asking for, say, 10,000 documents, what's reasonable for that? And that's going to be pretty subjective. So that's one of the things that's being discussed right now. Some of the other problems that we have is, while I care very much about public documents, not everybody, when you go to a city office or a county office, whoever you may be asking this for may not understand them. So you may be in the unenviable position of saying, I think this is public. And like everybody who works in a certain job, they have kind of the things they're used to and the things they think they know, and that may not fall into it. There's also something that is happening, and it's kind of, I wish it sounds like an old 60s album, but new trends in lawmaking, in which on the federal level and sometimes on the state level, they've been legislators or Congress has been adopting personal liability in information release, because we know what's happening with data breaches, and we know about HIPAA. You've heard about that. That's health insurance and health information, right? So one of the things that has changed, and this has happened in the healthcare and education fields, is that release of information. It used to be, if I was a public official and I gave you some private or sensitive information that I shouldn't have, I might be sued. The agency might be sued. Now, there is some personal liability creeping into the law that says not only would that agency be responsible, but so would the individual. So I, as just a line average worker, not the head of a department or an agency, but I could be sued. So this has changed part of the calculus of releasing public information. And I speak at some of these gatherings or organizations sometimes that are training public information officers. So they train people, and usually I have the unenviable task of following the people who are the lawyers that are risk management. And so very oddly, the question of public documents release often becomes a question of risk management. And what we are running into is that sometimes the many public agencies are being told, if you're sued by the media, even if they're successful, you might be out their attorney's fees. But if you release information to them that's incorrect, you could be looking at a lot more damages because of personal privacy and all of that. So that's one of the real challenges we're having, is that the agencies are being warned, make them sue you. And that's
Daryl,
not, yeah, go ahead, Martha.
I'm going to interrupt you there. to segue into something that's related, which is, you talked about timeliness and then some of these challenges, one of them being the risk analysis that the person who should be producing the documents is conducting. And one of the things that newspapers do and newspaper lawyers do is we try to convince the person we're talking to from the governmental entity that the risk is small so that that time frame shortens. We are trying to get the documents quickly. So one of the things that's really important is that because this is a balancing act, before you go and ask a court to do that balance, the newspaper or media entity or the individual person who's seeking that document is well advised to try and work it out with the agency.
Yep.
And we often spent a lot of time, Daryl and I, trying to figure out what it is exactly that we're asking for and in what manner that document we think exists would have been stored. So that we can bring those numbers down from, well, you know, you always hear back right away, oh, that's 10,000 documents. It'll take me 3 days. It'll cost, you know, a lot of money. And then you say, oh, but wait, what if we're just asking for things that occurred on this date or communications between these two people or something like that. So you're trying to constantly narrow, get enough information about what the problem is so that you can narrow the request to cut down on the expense, the timeliness, and the risk to the person providing it.
Yeah.
So-
And one of the really important things too, I think, and it's really, again, one of the brilliant aspects of Montana law. In some states, laws create kind of carve outs or exceptions for journalists. What's really great about Montana is Montana journalists have nothing special at their disposal other than they use this. They kind of use these laws often, but you as the public are just as much entitled to the same information as we are. The law doesn't create a special class of journalists. And that's really important because one of the things that we do when we ask is that the court, including the court that Justice Nelson sat on, and correct me if I'm wrong, Martha, said that one of that the media and the press has automatic standing because we appear at the meetings that sometimes we're the only audience members. We serve as the public's eyes and ears. We stand in their shoes. And so a lot of times people think that the nosy, pesky press is just being really demanding and kind of intrusive. But really what we're doing is we're just standing in the shoes of the public saying, we want to know that. So one of the things that we are often confronted with is if we get a no, we try to negotiate. And if we still get a no, one of the things that we have to, sometimes the challenge is figuring out what record you want and where it's kept. Because one of the things that you have to ask is the proper custodian of the record. And so you have to figure out what record you're kind of seeking and who has it. And sometimes that's a little difficult because the information you're seeking, you may not know in what form or format it exists if it does. So sometimes that's a challenge, but oftentimes when we are told no, we have to get usually in writing. And a lot of times my practice is I request them to tell me where in state law they are allowed to withhold a record. And there are some records that are interesting. Montana is one of 6 states that doesn't have police reports are not public documents or under confidential criminal justice data. That's different than in a lot of states. I started my career in Fargo as a cops and courts reporter, and every morning we got a stack of police reports to go through. That's different here. Now there's some ways around that, but you have to know what is in, but most things are public documents. And when they tell us no, we have a couple of different decisions to make. And those decisions are, we can get one of 3 requests. Yes, here's the document. Now, the hiccup or the wrinkle with that is I have 2 documents that I'm looking at right now that are requests that the state has said we'll look at it, and they're more than a year old. So this presents a problem. I may get those returned, In fact, I have friends who have I have one friend who waited 10 years for a FOIA at the federal level. So it's not just the state, it's federal. So you can imagine after 10 years how relevant that news will be, right? They fulfilled it, but did they? So we have to decide, what are we going to do with that? Are we going to accept it? Do we sue them because they're not moving fast enough? That's a difficult thing to do. And then secondly, they can say no. And if they say no, we have not a lot of great options, which is if we say no and walk away, we have taught them and we have set the precedent that we're not going to fight, which could be used in future lawsuits against us when they said, well, you accepted no here, but why didn't you accept no there? Secondly, when we're told no, we have to say, okay, well, we might have to sue. And from a practical standpoint, and I love the lawyers that I'm presenting with, but we have to, we routinely, if we are going to wage a lawsuit, we put $10,000 in the kitty for legal fees. That's what we just assume. That's okay for a news organization, but if you're just a member of the public, you're probably not, you probably don't have an extra $10,000 to burn. So that's a problem. The
Darryl,
other, yeah.
Let me ask a question if I
Yeah.
could, Darryl. You get a no, do you ever press the custodian of the document? On what basis are you depriving me of the document? Because the Constitution only provides one exception. Right of individual privacy outweighs the merits of public disclosure.
Yeah.
And if they come up with some other excuse, I guess I would explain to them that an excuse is not a constitutional reason for depriving you of the document.
Yeah, usually we ask them, and the language goes something like this, please, if this request is denied in whole or in part, please provide the provision in state statute that allows it to be withheld. We usually ask for that in writing because, again, when you go to court with a denial, you're going to want to know why they think that. And the first thing Martha asked me as a client is, why'd they tell you no? What did they say? Because she's trying to also ascertain the basis. Am I correct in that, Martha?
That's
When
right.
someone says no, you're going to say, well, why no?
And there are a couple other little reasons, if there's an attorney document, if it's an attorney-client privilege document, or there are a couple statutory exceptions that don't involve the right to individual privacy. But mostly, FERPA, HIPAA, there's some things like that that come up every now and then too. So there are some reasons that you'll hear that
Yep.
are difficult to work your way around.
I've had, for example, the Yellowstone County attorney, whom I greatly respect, Republican Scott Twido, has said on several occasions, Martha knows this too, listen, I don't know if this is public, but I'm going to say I don't think it is, and you can challenge me in court, but I'm concerned about it. And we've done that, and that's one of the most amicable that we're both kind of punting to a judge to say, help us interpret the law. And even though it is nominally adversarial, some public documents fights are truly fights, and some of them are more of just a difference of opinion, literally.
Yep.
And
Their risk management that you were talking about, where they're saying, I'm not going to give this up unless a judge tells me to, because I'm not sure about the answer.
Yep.
But Darryl, would you say that probably the question that's more difficult to respond to is, this is going to cost $10,000 for us to do the copies, or we're going to have an attorney look over every document. We're going to charge you attorney's fees for the production. So when they're now since 2015, when the statute was amended, you're required to ask for the document. And then if they're going to charge a fee, if the government entity is charging a fee, they have to predict what that fee will be, the actual cost it cannot exceed. And then you have to give them the cash before you get the documents.
Well, this is really the new way, because I think actually Montana case law is really, really very well delineated in this case, what is and what isn't, to Justice Nelson's point. This is kind of basic. So government, and this is nonpartisan and non-political. I've dealt with both administrations, and neither likes giving up information. It's very proprietary without respect to party. But one of the things that's happening right now is when they adopted a schedule of fees, they understood that to be, and I disagree. I'm gonna disclose my bias. I think that the legislature bought the argument and wrote the law saying, hey, this is above and beyond what we would normally do, so we're going to have fees for this. For example, copier, toner, but they also expanded it to staff time, which is a little bit tricky, because I think a reasonable question can be, isn't that what the government isn't that what they're employed to do, to serve the public? And if we're not journalists, we're the public, how do we have to then pay in addition? But that's what the law says, is that, for example, if we ask for information that has to be collected or collated or compiled into a special document. So for example, if the piece of paper we want just simply doesn't exist and someone has to produce it, they might be a bit able to charge us for that. And that's, as Martha said, a reasonable time. What we're seeing much more, in fact, the Billings Gazette is litigating this currently. I'm so proud that they are, because this is what we get. Okay, you want these documents, that's fine. They don't dispute they're public, but they're worried about privacy and the information contained. And they'll say, you know, we would be happy to give this to you, but we need to have one of our attorneys look at it to make sure that we redact any personal or private information. And, you know, you're asking for hundreds of documents, and, you know, our attorneys that will do this charge $250 an hour. So we need 10,000. The last document request that I knew that they were litigating, which was, I believe, against the Public Service Commission, the PSC requested $31,000 before they would start the process. Now that is being challenged as unreasonable. And I think that a lot of people in the press and the media believe that if the agency has concerns about privacy, that's why the government has lawyers, and it should be incumbent upon them. We shouldn't have to pay to have a government attorney review it in addition.
Well,
But that
are these government attorneys, or are these attorneys they hire from outside the government?
well,
I'm kind of guessing that most government attorneys are going to be shocked to know that they're making $250 an hour.
it depends on which requests. A lot of times they like shipping it out to someone who charges more on the hourly. But again, we believe that if we're asking for information that is constitutionally public and they don't want to give it up, that's their issue, not ours. And we shouldn't pay for that privilege. But that is what a term that is, just, you may hear it called constructive denial. They're denying the record without denying it, because they know that the ability for any organization or business to cough up thousands of dollars. And one of the things about when you have an attorney review a document, with all due respect to the attorneys, a lot of times you get documents with a lot of black marks. So what they're asking us to do is pay money, sometimes a lot of money, with no guarantee that the information that we would get is either A, usable, or B, complete, or C, it even exists. Because a lot of times when we ask for public documents, we're asking for them because we don't know the answer. So if we don't know, and now we're paying to get information, this can be a real problem. And so that is the new trend we're seeing. And that's not something that's only happening in Montana. That's happening in a lot of places, but Montana is, I predict that this will make its way to the Supreme Court, and that they'll have to figure it out.
Daryl, before we switch over to the other statute, I want to mention that now so much of our documentation is electronically stored. And while it seems like that's a solution to the problem of production, because it's so easy to attach a PDF to an email and produce the document, that actually hasn't been the case. The electronic storage has resulted in, first of all, so much more volume of documentation, because people used to have to actually sit down and type or write a letter, and now bing, 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 bing. So there's more documents. And also they're stored in different ways that have caused a lot of questions. For example, if you're serving on a board and you're a private citizen, are you communicating with your fellow board members on your private email or in your cell phone? And if so, if it's public business, the public has a right to see those. But it does really create a problem, and you'll see that public board members, especially ones that aren't paid, you know, just the volunteer board members, there's a real natural reluctance to give up anything on your cell phone. You know, you're not making the distinction between, I did this as part of my board work. You're like, I did this on my phone and I don't want to give up my phone. So that has created more problems than it's probably solved. The proliferation of electronic.
Absolutely. Oftentimes when we ask for email, they'll ask us for a term search, which is fine, we can. But if you can imagine, if I want to see Gianforte Department of Public Health and Human Services and Medicare or CPS, it's so expansive as to be almost irrelevant. And just to let people know, we were before I left the Gazette, we did have an ongoing fight with the governor's office, that would have been Bullock, on text that he sent from his cell phone. So this happens, this crosses partisan platforms easily. So that is and again, we have to decide, are we going to say we can't afford it and walk away, or are we going to fight it? There are remedies for media who sue successfully. They are out attorney's fees, but they're discretionary, I believe. And that means a judge has to also agree that they should have turned them over in the first place, or else if we get the information, we could still be on the hook for our own attorneys, which can be costly.
Tell you what, Daryl's cat just gave a big yawn. So
She does that a lot when I'm talking.
why don't we talk about the other, the open meetings law?
So the open meeting law flows through from Article 2, Section 8 and 9, the right to participate and the right to know. So as a member of the public, you have a right to attend any meeting except a few tiny exceptions. There's exceptions for pending litigation unless the litigation is between two public entities. Exception for personnel matters. For example, the school board can close its meetings when it's discussing personnel. Contract negotiations in some situations can be closed. Those are the general exceptions. But for a great majority of time, when a public body is meeting, that public body must meet in public. So what is an open meeting? The Montana Supreme Court has tinkered around with that over the years and looked at those constitutional provisions and weighed them against each other many times. And basically it kind of boils down to three really important things. A meeting is open only if the public knows that the meeting is going on. So there has to be some notice that the body is meeting. The notice requirement flows from that. It can't be open if nobody knows it's happening. Secondly, the public has to have a reasonable opportunity to participate in that meeting. That leads to public comment sessions at pretty much every meeting, from a ditch board to meetings of the Montana Board of Regents, from the most formal to the least formal meetings. And third, the public has access to the same information as the governmental entity. One of my favorite cases of the Montana Supreme Court is called Bryan versus School District 2. And that is a case that really brought great focus to the right of participation. And the thing I love about it, while I appreciate that journalists are out there standing in our shoes and opening meetings and finding documents, the plaintiff in this case was a mom who wanted to comment on the closure, potential closure of a school in Billings, Montana. And she went to the meeting. First, the closure issue was delegated to a subcommittee of the school board. So that brought up a really important open meeting facet, which is if the body that's making the decision delegates that duty, then the delegated body, the committee, the subcommittee, must also comply with the open meeting law. You can't get out of the open meeting requirements and the deliberating in public by delegating the duty, even to a single individual. You delegate, as Billings has, to a superintendent of public schools to make a decision. The superintendent still must meet in the open and take public comment. So Barb Bryan, in this case, went to the public meeting that was delegated to this subcommittee. She tried to comment and found out afterwards that the school board committee, the subcommittee, had information. They had these spreadsheets that they were working off of that Ms. Bryan didn't have. And in a really important decision, the Montana Supreme Court said, the right to participate is meaningless if you are not in possession of the information that the public body is deliberating over. So if the public body has facts and figures and you're up there making your argument as a member of the public, the Montana Supreme Court called that a paper tiger, because there's no teeth. There's nothing meaningful about that comment. It's just somebody talking without the information and the ability to rebut the information that is before the committee. So those are the three basic ideas about open meeting: that the public has to know the meeting is happening, the public has to have a reasonable opportunity to participate, and they have to have the same information available to them as the public body.
Let me ask two questions, Martha and Daryl. The open meeting laws can be abused, though, and one recent Supreme Court case that y'all lost was the one where the legislature has a couple of sequential non-quorum meetings and gets their act together, and then the decision's already been made, but they don't have to have an open meeting because it's not a quorum technically. And then the other one that I ran into talking with a journalist, that she would go to a commissioners meeting and the commissioners wouldn't deliberate anything. They'd sit around and text each other. So how does the open meeting law figure into those?
Regrettably, I can't remember which entity sued on that, but I agree with you, Justice Nelson. I didn't agree with that decision. I respect it, but I didn't agree with it. And public bodies will, I think that one of the reasons that the open meeting law is circumvented by public entities is that public officials don't want to look stupid in public. It's a lot more comfortable to have the decision and your little speech in mind when you're at the meeting. And so there's a natural tendency to kind of try and dictate what's going to happen before it actually happens, which isn't the best way to do business. But Daryl, you have more experience with this with respect to the quorum and serial meetings that we've been experiencing.
Yeah. So the one of the things that it used to be, so the original open meetings laws were passed to stop the good old boys from meeting in a coffee shop and making decisions. And so that kind of worked for a while before the advent of cell phones and emails. Because it was hard to not meet. And, and in Montana, for example, Yellowstone County, my home county, it has 3 commissioners. So if 2 of them talk about something, that can be, in fact, it is a quorum violation if they're deciding. So they have to be very careful. In fact, it's oftentimes why if there's a chamber ribbon cutting, you see 1 commissioner there, because if there's 2, there raises the question, should have they noticed that they were both going to be meeting at the same time? So there's a bit of a not a game, but a consideration. It's a little odd when you have 10 people, it's a lot easier than 3 at sometimes. But what we found is now in the advent of email and texting, it's becoming easier to request those documents through the right to know and see if they've been engaging in basically what we call serial meetings. So serial, not like Cheerios, but serial as in sequential meetings. And that's actually becoming easier. And I will say, to Martha's point, if they thought they looked stupid in person, text doesn't get much better. So that is one thing. Couple of things that I'd like to hit on real quickly is that in order for business to be conducted, there must be a quorum. That's a word that I think a lot of people are familiar with, but it basically means at least half the board has to be there. Some entities have what I call a 50+1 rule, which is they have to have a quorum plus one, so they have to have slightly more than 50. That happens a lot of times in even number boards where you'll have 6 and 6, so they have to have, like on a 12-member board, 7. They have to give notice, and they also there's a remedy for. So if you think this has happened, the law actually, and Martha, I'll let you describe this a little bit more. If you think there's been a violation, you have to act pretty quickly. And would you mind explaining that? Because that's something that can be really tricky, but there's a good reason for it.
So if a board makes a decision outside of an open meeting for any of the reasons we've already discussed, you have 30 days to challenge that decision. So you have to object within 30 days. It's a very short trigger, but it makes sense when you think about it, because once the decision has been put into action, or money has exchanged hands, something's been purchased, or policies have been instituted, then there's really no remedy. So the remedy that you get if you win in your 30-day challenge is that the board has to redo it. They don't have to agree with you, but they do have to listen to you.
Yep.
So that was the Barb Bryan case that I talked about earlier. She won that case, but it took a year, and much had happened with the closure of the school. But they had to have a meeting and listen to that brave Barb Bryan, who gave a very stirring speech about the closure of the school. And it wasn't much of a remedy probably at the end, but she made great law for the state.
And I will point out, this came up very recently. In fact, the Daily Montanan sued and won along with the MFPE. We because they had an interest when the Montana Board of Education, the lieutenant governor came down and wanted a whole bunch of things changed. It wasn't on an agenda, and it wasn't noticed. And the board, even against the advice of its chairwoman and its internal legal counsel, said this is not the way to do it. They voted, and within a week we had filed suit and we won that. We got it turned, or it's funny because the remedy is that they undid it, but they retook the vote they wanted to after noticing it. So it's a little bit of a Pyrrhic victory. We did win some attorney's fees, but not all. It cost us several $1,000s. But we believe that if we just let boards do that, then what's to stop them next time from this just becoming a common practice and slipping into tradition? So we do, while these things sound a little theoretical when we're talking about a legal framework or a statutory framework, there's something we use all the time and can prevail on. It's not I don't think that one was hard. It was so clearly out of bounds. So,
well, quite often they'll go back when you draw it to their attention. They will go back and redo it without a lawsuit.
Yep.
You know, we've had that occur numerous times.
You know, you both talked about attorney's fees, and I think maybe the public ought to understand that you can ask for these attorney fees be paid, but you almost never get them paid. And explain why that happens.
So the attorney's fees provision under Montana law, the general rule, the usual rule is that everybody bears their own costs of litigation, including attorney's fees. It's something called the American rule. So if you're going to shift fees to the prevailing party, an award of fees, there has to be an exception. And the open meeting law contains such an exception that says the court may award fees to the complainant if the complainant prevails. It's discretionary. And it's just not that much of a threat. The other problem with the provision is that courts have held in Montana that you can't get fees that are incurred in trying to recover the fees. So I had a case where I won, and they appealed the award of the fees and not the underlying decision. Well, the appeal cost more than the fees that were awarded, and I couldn't get awarded the fees on the appeal because we were seeking fees and those aren't included. So they wound up tipping the balance of winning in that because you wind up spending so much to keep the award of fees.
But
So it's not there isn't much teeth to it.
the net result is though that the media are effectively subsidizing the public's right to know. Is that correct?
Very few private citizens can afford to bring one of these causes of action. And it's difficult to navigate the procedures. They differ in every public body. I see my sister had a question here about what to do when you don't get a response to an email asking for a public document. And my answer would be check with that agency by phone and say, do you have a special form I have to fill out to get public documents? Because so many of them have their own little process. So it's a very difficult thing to navigate, but that's why I think the open meeting law is so important. Meetings are a primary source of information about your government, and you absolutely have access to them. And it's so much easier to fight to get into a meeting than it is to get into the weeds about what documents are actually in the governmental entity's possession that you might be able to obtain.
And to the extent that you don't have access to documents, that frustrates the freedom of the press, because it's the press that reports on the information in those documents. And if the press can't get them, then the freedom of the press is effectively shut down too. You know, we want to leave some time to field some questions by the public. And just wrapping up, Daryl, Martha, is there any salient point you want to make it right now before we go to the public questions?
The thing I really want to emphasize is that, especially with respect to participation, that's not just your right, it's a duty. It comes with responsibility. We all have the opportunity to go and observe our public bodies. And boy, your Constitution so much more specific about that in the state of Montana than in any other state I know of, and in the federal system. So that is a right you have, and it's also, I think, duty.
I would just say very quickly, and I'd love the questions. Rights are like muscles, exercise them. Exercise, ask questions, ask for documents, practice democracy. I found that, like most journalists, we know who to go to at times, and we didn't learn that. We didn't come out of college knowing that. We have to learn that. So learn democracy. And when it frustrates you, challenge. It's uncomfortable, but maybe I just like the fight too. I wouldn't deny that.
Okay. Thank you both. Suzanne, have you got the questions to field?
I do. Well, thank you both so much. This was just fantastic. It's really exciting. Let's see, we have, I don't know, almost 10 questions, and they're all beautifully written. So here's the first one. Can local legislative bodies set fees at a reasonable level so that the high fees aren't a barrier to getting public information?
So the statute requires each entity to set reasonable fees or to set a process in place. And I think there could probably be a default to a legislative system, but it's not the way it works right now.
All right, here's the next one. I wholeheartedly agree that requiring payment for public documents from journalists or any member of the public is so wrong. I'm a legislator and former government PIO who voted no on that terrible bill to require payment. What are you doing as organizations to undo that terrible bill? Can we bring a bill to repeal the payment requirements? I also agree that staff time is part of their job, and charging for their time is wrong.
So a lot of the fight in the Montana Newspaper Association, I can't speak for the broadcasters, has lobbied. I would say probably in the last 10 years, the we've been in a much more defensive position because the overall trend in lawmaking is to restrict access and try to make carve-outs. I think we would be willing to do that. We need to find sponsors. And one of the challenges with legislators is that they hear from the departments that we're short-staffed, we don't have enough time in the day. I will say the problem for me personally is I get I also manage a business as the editor-in-chief. I get that toner and copies are expensive. It's certain other fees. And if I need someone to really build a report, one of the challenges is, or what challenges are, you have proprietary software keeping information in state agencies. So to extract that is going to take some time and may incur expense. So the how do you disaggregate the good fees, so the reasonable from the unreasonable, is really tough. I am all for, I would be happy to talk to legislators to lobby. They probably don't want to hear from me, I'm guessing, but to lobby for it, because I do think if you can't afford it, does it really matter? I mean, how public it is?
Thank you. And you may have answered this one. Is an advisory board / committee that makes recommendations to the governing bodies subject to open meeting laws?
For the most part, yes. There's a case called Croft. Croft was the president of MSU, and this is one of Daryl's favorite cases. I don't know why it thrills him so, but it does. In Croft, the president of the university system had a system where he would meet with department heads and discuss everything and then make a decision. And the Montana Supreme Court found that that was the deliberation of a public body because they were deciding something. They were vested with the authority to make a decision. So those little cabinet meetings became open to the public.
All right, here's another one. I'm a reporter for Yellowstone County News. I've been following an officer-involved shooting story which occurred 8/12/22. The man who was shot by an officer still has not been identified by the police department. Their reasoning is they are, quote, still waiting on results from the crime lab, unquote. And so, quote, the man has not been charged with anything yet, end quote. Evidently, the man in question is still alive. Is their reasoning valid in any regard? And or have you ran into similar situations before?
Yes, and it sounds to me, Yellowstone County News reporter, that you are in the quagmire that is the Confidential Criminal Justice Information Act. Daryl talked about police reports. Until it comes out of that criminal system, they don't have to produce things. And so that's a problem for reporters all the time. And one of the biggest problems with it is sometimes investigations never end. And so it stays in the confidential criminal justice qualification for years.
I'm aware of that case. And yeah, we one thing to remember, I'd like to bring up another point, because this is something that we run into, and it's rarely legitimate. Stamping draft on something does not make it inaccessible. Documents are documents, and unless it's, for example, a draft of a legal settlement, a draft of a personnel file, or even drafts of policy at the city council level can be public. So some people say, oh, well, we'll give it to you, but it's in draft form. The law, for the most part, and Martha or Justice Nelson, correct me on that, just stamping draft on something does not make it off limits.
In fact, in the Barb Ryan case,
yes,
the documents were drafts that she did not have. And Daryl's right. Draft is still a document. It has to qualify for withholding under some other specific reason, attorney-client privilege, expectation of privacy, that kind of thing.
And one of the things that I will say, can I make one more? In public documents, when you ask for them, there should be a weighing test. And Martha's taught me two really good things. So I want to say, most of the time when we when there is a when you want to know about a public official or a government employee, their right to privacy is kind of predicated upon what job they do. So the balancing test, usually the public's right to know usually goes up as two things happen, either as they deal with public money or they're in a position of public trust. So if you think about that, most of the time the media is very, very successful in getting information, even personnel information, about teachers and police. Now in other states that I've worked in, personnel information is a lot more, public employees information is a lot more generous. But because we have that individual right for privacy, if you want to go in and just say, want to know about your a secretary's job, that might not be something that is accepted. So know that that's part of the balancing test, is how public, how much money do they touch? So thank you. Sorry about that.
No, thank you, Darrell.
Thank you. That's great. There's a couple comments about SB 232, which would set timelines on records requests. What draft legislation other than that are you aware of that may affect the public's right to know, or can you comment on SB 232?
I've read it once, so that doesn't make me an expert. I've been in states where they have that. For example, Utah, when I was there, had a 7-day and then a 5-day at what they call expedited for news media. So public got 7 days, we got 5. I've got real mixed feelings about that because what constitutes a response? For example, saying we've received your request can constitute as a response. It doesn't fulfill the records request, but and the other thing that happens is if you wanted, and I always use the one sheet of paper that you know they have because you can see it on their desk. Sometimes if they're not feeling particularly generous, they say, okay, we'll get it to you. The law says we have 7 days. And then you get into, is this business days or working days? And does that count holidays or weekends, right? So I've got mixed, I would like responses, and I need to read that bill further, but I've got mixed feelings because I think both can be abused. Justice Nelson has always said the public's right to know is self-executing. That means it doesn't, and forgive me if I'm misquoting you, Justice, but
No, you're not.
it's there. You don't need a reason. You have a reason just by right of states or being a state resident. So
And the court has held that the right to know does not require implementing statutes either. That's one of the things that makes it a direct action statute. You can just sue right on the constitutional right.
All right, it looks like we have time for one more question. Are staff or work group meetings of only executive branch personnel subject to open meeting laws, or would it require the presence of a member of the legislative branch to be subject to the law?
I would figure out how close that group looks like the group in Croft. You look at what authority they have in the decision-making function of that branch. So it doesn't necessarily require somebody from another branch or a deliberative body. If they're making a decision, for example, say on the budget, what budget they're going to present to the executive branch to the legislature, and they had some authority for that, you'd have a good argument that that should be subject to the open meeting law.
All right, well, thank you very much for the Q&A. We had a couple other statements that we weren't able to share tonight, but I did want to hand it over to Justice Nelson for some closing. Just a reminder that this will be on the library's YouTube channel. So it's Lewis and Clark Library on YouTube, and we'll have it up there within the next few days. So thank you all very much. I'll hand it over to Justice Nelson.
Thank you. And I want to thank both Martha and Darrell for their discussions tonight. It's been very elucidating, and I think the public has learned a lot about these statutes and constitutional provisions that they didn't know before. And thank you, Susan, for all of your technical help. These things just don't go off unless you've got good people back there running the show and pulling the strings. Martha and Daryl have both made the point that democracy is not a spectator sport. If you value your constitutional rights, if you value your democracy, you gotta stand up and fight for them. And as of late, I think you've got to fight pretty hard. What specifically can you do? For one thing, know your legislators. Know who they are, know what their positions are, and don't be afraid to email them, call them up, be the squeaky wheel that gets the grease, pin them down, get answers. Don't stand for public, the politicians answer. I ask question A, you answer question D. Don't settle for that. You want specific answers, pin them down, know your legislature. They work for you. They work for you, and expect them to serve you as a member of the public. Tell them what you think. Again, don't be afraid to do that. Support your local media, and very often that requires some measure of financial support. These lawsuits cost a lot of money, but that's just one phase of what it costs to run a newspaper anymore. And I'm sure Daryl could tell you more about that than I ever could. But support your local media. Stand up for the press. Stand up for a free press. Write letters to the editor. The newspapers are more than happy to publish your letter. They have a few rules, not difficult ones. They have a few word limits, and you can't be vile and defamatory and that sort of thing. They won't publish poetry, by the way. But write letters to the editor, and you get those in the paper. People read the papers. People read what you have to say. Well, I know Mary Jones. She's my neighbor. I know John Smith. I've heard him speak at meetings. So do those things. Know your legislators. Understand their positions. Tell them what you think. Support your local media. Write letters to the editors, and go to public meetings. Go to these congressional or legislative hearings. Stand up. Say your piece. If you're against the bill, get on the list of opposition. If you're for the bill, by all means support it. But get up and say your piece. Democracy is not a spectator sport. And if you're going to sit in the stands and do nothing, we're going to lose it. And again, thank you all for participating in this very important webinar. I'd like to thank League of Women Voters of the Helen area and the Lewis Clark Library. I'll tell you, these two organizations have done a tremendous public service over the last year or so. They've put on a number of webinars, and they're focusing on the Constitution. And we've got, I know, some more in the works now anyway. So thank you all. Thank you, Suzanne, Daryl, Martha. Thank you.
Thank you.